Okay, well, good afternoon, everybody. My name's Fay Collinson. I'm a barrister at King's Chambers, based in Manchester. I'm joined today also by Alexander Wright. It's Alexander, not Alex, who is a partner and deputy at Boyce Turner. And today, we both intend to speak to you all about this topic, which is changing the professional deputy. Is it in P's best interests, or is it deputy shopping? And the reason that Alexander's been asked to speak with me, because both him and I have quite strong views about this particular topic. Now, today, I'm going to be speaking a bit about two key cases that I think need to be on your radar. And then we're going to launch into a discussion between Alexander and I. That may prompt some of you to want to ask your own questions. So please do use the chat function. It's always a bit difficult to address questions as you're going on, you're in the throes of a conversation, but I'll do my best to monitor those and see if we can address some of them. Okay, so before I get going, I always introduce myself. Some of you may know me very well, some of you may not. I practice at King's Chambers, and I have a practice area that spans three particular areas: wills, trust and probate, contentious and non-contentious, and property and affairs court of protection, and then also property work. So I regularly advise deputies on matters of property, wills, trusts, all sorts of things. And what very often comes across my desk are questions from deputies about applications made by a proposed deputy seeking to remove them. I mean, at the moment, I seem to be having one a week at the moment. I don't know why that is, but there certainly seems to be an appetite for these applications. I also practice as a mediator as well. I'm going to be talking during the course of the discussion about my views on the importance of mediation. I hope some of you will share those views. If you don't, be open-minded about it. I'm a huge advocate of mediation, particularly in this jurisdiction, where I think it's actually rather underused. I very often operate a sort of open door policy. I regularly invite people to contact me to ask me about matters and discuss things informally. Try to get back to people as quickly as I can. But there's my email address, fcollinson@kingschambers.com. The email address under that is also that of my clerk, Luke. So if you wish to get in contact with him or me, then please do so. Now, what is deputy shopping? Now, Alexander and I had a funny conversation about this earlier, because when I sent out the invite for this, he said, well, he sort of coined my phrase from my article on my website. And I thought that was funny, because I had actually picked it up from my years ago. I'm talking when I was sort of a pupil and I did personal injury. There was regularly this topic of expert shopping. You turn up an application where someone was trying to get a new expert. You say, no, they're expert shopping. They just want to get an expert that says what they want them to say. So effectively sort of gun for hire. Now, sometimes we have to remind clients, or not necessarily clients, the individuals who approach the proposed deputy, that it is absolutely your right to instruct whichever solicitor you want to do. And you can scan the market to see who is the best fit for you. With a deputy, it doesn't quite work like that. But that is very often, in my experience, forgotten. You are not, or P is not, or their parents are not entitled to shop the market for a new substitute deputy. When the initial application is made for the first appointment of the deputy, that's where there's scope, I think, to have a meeting, or sometimes a beauty parade, as some people might call it, with proposed deputies, and see who is the right fit for P, because there will be some firms, some trust corporations where they aren't the right fit. That is where it's probably more appropriate to shop around and peruse the market. But if you have a professional deputy who is already in place and going about administering the estate, sometimes P or their parents can fall into the trap of thinking that, having maybe had a disagreement or a little bit of a falling out, that they can just go to a different firm and seek the transfer of the deputyship. And sometimes in more extreme circumstances, they will repeatedly go to a new firm until they find someone, or they think they find someone, who will do what they want them to do. Because, of course, when you're acting as a deputy, and Alexander will know this, you have to make decisions that sometimes P's parents or P don't agree with. And that can lead, and sometimes does often lead, to a disagreement between the family members. And it's how we manage that. So that's, in a nutshell, what I think to be the concept of deputy shopping. My view and my experience is I think it's growing. I think there are possibly a couple of reasons for that. I think that the COP jurisdiction has up until now been shrouded in a little bit of mystery. Some firms who perhaps are wanting to break into a new market, and they're entitled to do that, may see that there is an opportunity to enter into the world of the deputyship. And sometimes, as I say, individuals may not just realise that you can't just change a deputy like you can a solicitor. So, and I took this email from one of my cases, and I see this quite often, actually. Some of you who are listening may well be working in firms on behalf of deputies or in trust corporations, where you get an email from a new firm or from a lay client saying, we want to instruct this firm, or we want you to transfer the deputyship file from your firm to this new firm. Please arrange to do this by X date. And in my experience and my view is that you're simply not entitled to do that. Now, the case I'm going to talk about initially is the Cambly case, and many of you who are here will probably have heard about this case, but it certainly deals to some extent with the issue of deputy shopping, although arguably it doesn't go as far as it might have done. But it's an interesting case to go and read, and I encourage you certainly to do that, because if you are faced with an application, certainly defending an application, it has some useful dicta from Her Honour Judge Hilda that would serve your purposes when you're perhaps approaching a DRH hearing or a contested hearing, to make sure the judge is aware of some of the principles that need to be applied in these types of applications. Now, this case has a background to it, and if you want to know the full background, go and have a look at NKR and Thompson Snell, because it had a little bit of a protracted history. P was a minor. I think he had a sort of relatively significant clinical negligence claim. Initially, his deputy was Wrigley's. There was then an application to remove Wrigley's by P's parents. P's parents for a long time had wanted to become P's deputies, but they were unsuitable. Certainly the father was unsuitable because he was convicted of fraud offences, and his mother was involved in the business with which P's father was associated. And so there are issues of insolvency. So P's mother was, by virtue of that, also unsuitable. The first proceedings were brought by P's mother, I think, and also bizarrely a direct access barrister. I always find it amazing that that person wanted to put themselves forward as a deputy, because I've not heard of that being done before. But it was suggested that the second deputy who was appointed, which was Thompson Snell Trust Corporation, should again be removed and in its place be substituted a direct access barrister. And so the history to this second instalment is that there were two previous breakdowns of a professional deputyship. What happened in the first case was that it was agreed, I believe, that Thompson Snell should step aside. They did that by agreement. The issue is whether Miss Sood was suitable, particularly in terms of her bar mutual insurance, or if she weren't, whether it should be a panel deputy. And the outcome was that a panel deputy was appointed, which was the applicant in this second instalment. Now, it seems from the second judgment that things just got worse. It struck me that it was a very, very challenging family. And as a result of that, the panel deputy had faced numerous challenges in trying to effectively administer P's estate. And I pause there to say, if you have a panel deputy saying, I don't think it's in P's best interest that I continue because things have got that bad, that is usually a good indication that the circumstances are quite bad and are quite extreme, because of course panel deputies are there to deal with the most difficult cases. Now, initially, the application was made by the panel deputy and it was refused on paper. And It was noted on the court order that there was an exceptional turnover of deputies, and the application indicated that there was a systemic failure in the administration of P's estate. What happens next is that the panel deputy sought a reconsideration of that application. Just pausing there, that's always a good piece of armour to think about if you do need to have a judge re-look at another judge's decision without actually appealing, because very often in the COP, and this differs from the civil jurisdiction, is that things are very much dealt with on paper because it's cheaper to do that for P and it's quicker. Sometimes, however, and I've had this in my own cases, it can lead to a judge making the wrong decision because they haven't seen all the file. Sometimes there are difficulties getting the papers from London to one of the hubs. Or sometimes it's just a case that they've not thought about other issues. And so there is the power for the court to reconsider and effectively look at it afresh. And I think that's actually a really useful power in the COP. So I often use that in my cases. And this panel deputy said there was an irretrievable breakdown. And that is a term I see very often in these types of applications. And there was an irretrievable breakdown in the relationship between the deputy and P's family, but importantly with P's father. And the judgment lists what the kind of difficulties were. The father's repeatedly bad-mouthing the staff, the deputy, lots of emails, unfounded emails, accusing them of stealing from P, being corrupt and being criminals. Also, what he was doing was unilaterally instructing tradespeople and OTs to carry out work at the property without getting the deputy's refusal, and then just expecting payment for those without the deputy having any input in the decision. He was also asking the deputy to make decisions that clearly weren't in P's best interest, for instance, selling land to P's father at undervalue. And this is, I think, one of the interesting points is that about this judgment about the deputy's costs, because that was a key feature in why the application was made. As we know, when we have a challenging family, the time that you have to spend in dealing with that file is much greater than in other cases. And so here, a great deal amount of time was required, but the father was objecting to payment of the fees. And he was also recording meetings, which I always think is, if your client's doing that, you're never off to a good start, I think. So the deputy said, and this is a quote, that he cannot be enslaved to a job for life. And I think the fact that he uses sort of that type of language is an indication of how difficult it had actually got for him. Because as I say, I think it's quite rare for panel deputies to make these types of applications. The other point he made was that there were financial ramifications to the difficult relationship between the deputy and the family. He said, I'm spending a huge amount of time on this file, but I'm not getting it back from the SCCO because it's all being knocked down. So I, as the deputy, and I'm only doing this in the course of my business, am being financially prejudiced to that, for that. And that's an interesting point that I'll come to in the case of Cumbria in a moment, because in the Cumbria case, the local authority sought their substitution as deputy in favour of panel deputies. And one of the reasons they said, well, the fees just aren't enough for us at fixed fees. And the High Court judge there said, well, that's not an appropriate consideration because it's about P's financial interests, not the deputies. But here we have an example of an application in front of Hilda where actually the financial implications of a bad working relationship on the deputy are being put forward as a ground for his removal. And I think that's a reasonable one to make. And as a result of all the bad relationship, decision-making was being hampered. He didn't say, as far as I can see, that he couldn't make decisions, because sometimes you do get that, just that it was making it more difficult. And he said that the father was intent on breaking down the relationship he has with the deputy by deputy shopping until he finds a deputy who will accede to his demands. So what we have in this case is, and this is why I say it's quite an extreme example, I think, of a family member who is just intent on doing everything they can to make sure the relationship breaks down. And that's when it becomes a difficult issue, because how far does the court go in acceding to that request? Because in a way, it's rewarding bad behaviour, which in the long run, I think is unlikely to be in P's best interest. But it was a very tricky application, I think, that Hilda was faced with. So the application was supported by the parties. So you've got the parents as parties, and you've also got the OPG. The OPG's position was that even if there's a new deputy, the family's not going to change. There's still going to be that really, really difficult dynamic. And I think that, to me, is always a key feature in these applications, and why you can look at the cases for points of principle that you can apply. But the reality is every single application has to truly be determined on its own facts, because there may be a family dynamic that means that an application in Manchester must be dealt with in this way. But if you have a slightly different dynamic being dealt with in a different court, it has to be dealt with in a different way. So I thought it's quite funny when the OPG said this, that they recognised the dynamic wouldn't change, but they needed to be firm with the father. I mean, I suspect that the panel deputy had tried to do that so far. I hadn't succeeded in that, unfortunately. It got to the point also with the panel deputy where things were so bad, where the firm was actively considering taking legal action against the father. They didn't say what, but I suspected it was probably issues about harassment, because I think he was repeatedly sending emails that he shouldn't have been sending. And the OPG said, well, that's still open to the new deputy to do that. I mean, I don't think that any new deputy would relish the thought of bringing proceedings, especially when the OPG was saying, well, that's not something P should pay for, but it should be the firm. So interesting point to make. And I suppose in a way, it shows that actually how difficult it can be for a deputy, that they have the misfortune of having a family that is very challenging, and an extreme example here, but yet they may find themselves in a position where they're actually severely financially prejudiced by that type of file. So Hilda's decision, she allowed the application, which I was quite surprised by, actually. And what she did was she appointed the father's two first cousins in place of the panel deputy. Now, the two cousins were appointed in a personal capacity, but one of them was a solicitor, and one of them, I believe, was involved in financial services. So they had a sort of professional background, but they weren't being involved as a deputy. So I think that probably had some relevance. And it's interesting, I think, that Hilda had recognised that it wasn't working with a professional deputy. She also raised in one of the orders, from what I can tell from the judgment, that the court was considering injunctive relief against the father in order to stop this continued breakdown between the family and the deputy. Because the problem is, if you keep acceding to these applications, history just repeats itself. And so it gets to a point where you have to change the approach and carry out more draconian measures. I have to say that, to me, is extremely rare in these kind of applications in the P&A jurisdiction, much more so in the health. And I sort of discern from the judgment, and knowing how, Hilda approaches these applications, I find with great sympathy and sensitivity, and she does try to think about things pragmatically. Perhaps giving the family an opportunity to demonstrate they might be able to manage the affairs, not taking it as far to allow his parents to be involved, but seeing if there is a way of moving forward by allowing the family to have some involvement so they feel some element of control, but still having it without his father being directly involved. So we will wait to see if there is a third instalment, which I have to say I wouldn't be surprised if there were. Obviously, I hope there isn't, because I hope it works for them. But there may be, it's not a case that I was involved in at all, but there may be a part 3 where, if that doesn't work, Hilda may then have to go and consider, well, we've now tried everything. What else is there to try? So it'll be interesting to see whether there is justification in the future for injunctive relief. And Alexandra and I were talking about this earlier. We're sort of wondering, where could the court take that? Because you can stop the father from contacting the deputy and things like that. But how practically is that going to work if P's father is a primary carer? They live with them. So it presents a whole host of issues. And this is why I think professional deputy removal applications are perhaps the trickiest ones that we as practitioners face. So I've just put down here a couple of useful quotes, I think, for you. If you've got your own applications, you might want to refer the judge to some of these. The starting point is that when a deputy encounters difficulties, the response of the court should not be to change the appointment as a default response. To me, that's really important, because I think there is sometimes a mentality that if P, who may be less impaired and so can ventilate their wishes and feelings much better than other individuals, or their parents want the change, sometimes there is a misconception that they're entitled to it. And one of, I think, the key learning points is they're not. It's not an automatic right to a change of deputy just because P or their parent wants them to. And the reasons for that are obvious, but some of them she speaks here of changing a deputy inevitably incurs costs which would otherwise be avoided. The costs of changing a deputy, I think, get forgotten. Often in the cases that I deal with, a judge will require the outgoing deputy to set out the costs of the change. And I think that's quite important for those of you who are responding to applications. If that is a material factor, so you might have P who is of limited funds, that, for example, their claim is ongoing and they've got a limited interim payment. So they do actually have finance funds at the moment. They don't have CHC funding, for instance. And so the change of a deputy and the change of the cost of the case actually going forward to a trial, if that is going to detrimentally affect P, the court needs to know about that. And that is evidence that has to be provided, because otherwise it's not going to be before the court. The judge dealing with it may not be experienced in this particular area in practice to know what the realistic and pragmatic consequences of a change will be. So I think it's incumbent upon a deputy who's seeking to be removed to set that out for the judge. And she goes on to say the risks being perceived as rewarding negative behaviour, which in turn undermines the prospects of future stability. Rather, the court should probe the actual circumstances with a view to salvaging working relationships if possible. Alexander and I are going to come on to how we think that should be dealt with. But I think the key point here is that you shouldn't just be making an application like you might do in a civil case. So, for example, in a civil case, you have the pre-action protocol, you have a bit of pre-action correspondence, and then ultimately, if you can't agree on the issues, somebody issues the claim. It works differently here, because the impact on P is of huge significance that I think has to be borne in mind. You have to think with not as a litigator, I think, with these applications, you have to think about how you can salvage things. And as a representative representing the person who wants the change, you've got a duty to advise the client, actually, you can't just bulldoze in there and seek removal. We've got to think about whether there's an alternative way of dealing with this. Is there some way we can collaborate to try and make sure that there's a workable solution? So that's where I say mediation actually comes in incredibly effectively. Here, the judge went on to say, unfortunately, in this matter, such support as is offered to both sides by the Office of the Public Guardian has effectively been tried already without success. Just pausing there are two key points from here that the Public Guardian tried. The Public Guardian provided a case manager, which some of you will have involvement with, and the number was given to the deputy and also to P's father as a point of contact to try and resolve disputes. And the reality is P's father didn't engage with it. So these are the sorts of things that you need to be thinking about. If you are approached by somebody to make this application, you do really need to be making them aware that they need to be trying these other steps before you actually think about litigating. The other aspect that was considered was kind of like a contract of expectations. Some of you who deal with health and welfare cases will know that that's very often a facet of contact cases, or if someone's behaviour is compromising a care package, the court will set out in a schedule to the order an expectation contract of how everybody should be behaving. So it's there in black and white before lay individuals about what they should and shouldn't be doing. That was tried in here, but the father basically said that I'm not doing it for X, Y, and Z reasons. But in most cases, I would hope that thinking about things in that way may well work. But here, she goes on to say that in the context of AR's less than constructive response to the proposal drafted by the deputy and endorsed by the public guard, Mr. Cambly's unwillingness to act, even if an agreement were to be reached, looks more than realistic than obstructive. So Hilda's saying that in this case, everything that can be tried has been tried. And so the court is really left with no other option. But there is a magnetic factor here, which I think is important. Well, certainly I perceive this as being the magnetic factor, because you'll remember the grounds that were put forward for the application, which were the financial consequence to the deputy, the irretrievable nature of the breakdown, and also that it was making decision making very difficult. She says, in those circumstances, in my judgment, it is clearly not in best interests of P for the current deputyship to continue. Aspects of managing his financial affairs, which should be straightforward, such as agreeing expenditure for a holiday, will be drawn out and acrimonious, and costs will inevitably be higher than necessary. Since deputyship does not operate in a vacuum, P's living arrangements are likely also to be adversely affected in terms of household stress. It is these considerations, and not in themselves either Mr. Cambly's withdrawal of consent or AR's inappropriate behaviour, which point to the conclusion that the current deputyship appointment should be discharged. And I think that's of real importance, because what she's saying there is, yes, Mr. Cambly doesn't want to be it anymore. That's not a magnetic factor. Yes, Dad is behaving inappropriate, but that's not a magnetic factor. But the magnetic factor, which is causing me to make this decision, is the impact on P. And that's why I say these decisions are so fact sensitive, because I have had cases where there may be a real struggle to keep a deputyship going and decision making may be very difficult. But the consequence to P may actually be harmful of changing a deputy. I had a case recently where there was evidence from the case manager that changing the deputy at this time was going to, or was likely to, cause a step down in P's mental health. And when you're faced, or when a court is faced with evidence like that, I personally do not see how it can conscience a change in a deputy. Ultimately, that was resolved by consent quite properly. But the focus on P and the impact on them financially and also on their welfare, I think, is primary significance. And it cannot be underestimated, the impact of hostility and litigation on P when they are at home. And that's often something I say in stat will applications. Sometimes you get young adults who know what's going on. They know that there is a dispute. They are at home. They hear their parents talking about it in their kitchen. They hear their parents on the phone to the deputy having an argument. That all has an impact. And sometimes that's actually forgotten. But to me, that's always should be at the very top of the hierarchy of reasons for making a decision. So just some key points for you, I think, on sort of professional, but also other removal applications. I have to say, pausing there, I think that with removing lay deputies, in my experience, it becomes obvious, really, whether they need to be removed. Very often it's because they've done something they shouldn't have done, they've misunderstood their duties, or they are refusing to pay care fees, things like that, where it becomes easier to give advice about what the court's likely to do. But with professional removals, I think it's much more difficult and it's much thornier, because also it's not particularly attractive, I think, to have two firms of solicitor arguing it out in a courtroom. And Judge Hilda does not like that, and the COP doesn't like that, and I can see why. But there has to be remembered that the best interest analysis in Section 4 requires consideration of a number of factors. But one of the key things is that the removal is not a fait accompli, and I stole that from a judge who used that in a judgment in response to one of the submissions I made about why somebody should be removed. And don't just think that because the parent said, I can't work with this deputy, that's going to be enough. I think you have to go beyond that and show that, yes, there may be a poor relationship, but can the relationship work if we try to go back and sort it out for everybody? And the guide will also be P's best interests, including the financial interests. And there's reference to the Cambly case, if you're involved in this kind of legislation, I'd encourage you to go and read it. It has some actually really useful dicta in there that I will very often put in my skeleton arguments. And there, the High Court judge said that there is no automatic right to somebody stepping down as a deputy. So even if Alexander one day decided, I cannot do this anymore, I need to hand this over to somebody else, well, the judge may say, no, I'm sorry, Mr. Wright, you can't actually do that. I think that's actually quite concerning for some professional deputies, but there we have it. So the continued consent to their appointment is not actually required. And here's a second really key learning point. The court and the parties have got to probe the circumstances before deciding whether to substitute. So you are, I think, treading a dangerous line if you just issue your COP one. If you send one letter and then go straight to issuing the application, there needs to be a discussion and there needs to be concerted attempts to try and repair the relationship. If it can't be repaired, then so be it. But I think that the way the authorities are going is that you have to demonstrate that those steps have been attempted and to show why it won't work. And also to show the impact of P on the status quo remaining. So that's why I raised the case for mediation. I mean, I suggest this in my COP cases all the time. And it is becoming used more commonly by individuals, especially in gifting applications, statutory will applications. But sometimes what's missing, especially in these days where everything is remote, so I'm conscious of the time, where everything is remote, is that sometimes things get lost in communication, and sometimes it just requires a discussion in that kind of formal setting where people have the benefit of representation and they feel that they can get their points across. And the mediation can be used quite effectively to set out a sort of agenda about how things are going to work moving forward and what everybody's expectations are about their conduct. Another point is that, in my experience, the court's unlikely to have a fact-finding hearing at these kind of applications. The COP judges, quite understandably, are so loath to use P's funds to pay for a trial on these kind of issues. And I think if you are two firms who are battling an application like this and you want it to go to a contested hearing, I always say to deputies that if you're putting yourself in that position, you are potentially putting yourself in the firing line for an adverse cost order. Not always. And that's where I preface that with, as a deputy, you, I think, have a duty to put forward your views on best interest in response to an application. Section 4 requires the court to take account of the deputy's view. So if you don't put forward a positive position on it, how can the court make sure it carries out the Section 4 checklist? So, and I will get involved with these applications quite early on, and we will think about very carefully about the extent to which we put forward a position. So you often have to think about how can the application be dealt with proportionately, and that will often lead to the parties inviting the court to deal with it on paper, depending on the application. But I will very often file written submissions and ask the court to deal with it on paper. Of course, you can always ask the court to reconsider if they come back with the wrong decision. And the final point I raise is that there is the possibility of asking the court to use its injunctive powers, but in very extreme circumstances. I have to say, I haven't personally come across the use of injunctive relief in this type of application, but I can see in the Cambly case that if things don't work out, that may be the use of a power of last resort. So if you do have those really, really difficult cases where actually it's having a harmful impact on P, then you may need to think about that. The sort of application that Alexander and I were really thinking about is, what about the opportunistic application? And to discuss this, I sort of put forward an example. And I come across examples like this all the time. So Mr. A is just appointed as a professional deputy for P, who is a young adult. There is a new file handler at Mr. A's firm that basically gets on the wrong foot. It happens, not everybody gets on. And he rather foolishly makes a comment about the way that their property looks, and they take umbrage at that. So they don't get off to a good start, but then things get worse because the deputy declines to approve payment of a family holiday from P's funds. The family are pretty miffed about that, and they try to discuss it with him, but he's not available for a number of weeks for various reasons. But then to add to that, because of COVID, P's portfolio is not performing well at all, such that the deputy has to go back and really look at expenditure. And the consequence of that is that the family care payment is reduced because it has become less affordable, which is a decision that a deputy is entitled to make. It may be one that family is not happy with, but deputies are well entitled to make those decisions, providing they're in P's best interests. And it's Mr. H who tells the family, of course, Mr. H is not on good terms with them, by letter. So what they do is they approach a firm asking them to make an application to change P's deputy to someone in that firm. And they send that email right at the beginning of the seminar seeking transfer of the file. Mr. A refuses the application in the pre-action letter. And what then happens is firm B goes to make the COP1 application with no further steps having been taken in between. And in the application, it's said that there is an irretrievable breakdown of the relationship between P's family and the deputy as the ground. And it gets listed for a dispute resolution hearing, which they always do once they become contested. So, and this is where I'm going to invite Alexander to pitch in, because I know he's a very experienced deputy running a number of files. And I canvass this question with you, Alexander, is that the right approach from firm B in just taking the very next step of issuing the COP1 application? If it's not, where do you think they could have done things differently?
I think, Faye, the first thing that baffled me was the idea that you would seek the transfer of the file first. I don't see how they could ask for that or how the deputy could agree to it.
Well, they can't, but they do.
So that baffled me. The second, just to go straight to COP1, is missing a lot of steps there. And I think the cases that you've spoken about have highlighted that the court expects much more than that. One of the things that we've tried to come up with is a sort of step-by-step guide that we will follow ourselves, and I think the profession as a whole would benefit from adopting. That one of the first things that you would do is, after speaking to the client and finding out, really, are any of the things that have been done actually wrong, or is this just badly presented? Is this unfortunate client care that can be corrected? And have they actually asked for a meeting? An in-person meeting with Mr. H and Mr. A, get them both there and really just hash it out. Because sometimes when people are busy, they make decisions to communicate in a poor way, and that can largely be corrected. And sometimes they can forget the lives that these people are actually living day to day, the stresses that they're under, and how they can take things the wrong way. If they won't accept that, then the first step would be to pick up the phone to the deputy, and be just writing a letter asking for the transfer, and then by making an application, you've got to really try and take steps to repair the relationship, because the court's not going to take kindly to you just throwing in an application to take over without even trying to help repair it. And I think we could all benefit from our colleagues at other firms doing the same thing. We should all be doing that. Try to repair the relationship with P and try to come to an agreement. If the relationship has broken down and the deputy accepts that, then ask them to put that in writing, ask them to confirm that they don't intend to object to the application. And then when the application goes through, the deputy will have an opportunity to explain in full not just the reasons that are listed in the application, but what other issues the court and the new deputy should be aware of before they take over, and to confirm that they won't object. So there are lots of steps to go through, I think.
To me, it sort of justifies the approach of a sort of pre-action protocol. And I was going to mention about how if some of you do probate work, you have the ACT-APS approach, which is where there's kind of like an industry standard that's not put into law or practice direction, but there's an expectation that people will approach will validity cases, for instance, in that sort of way. I mean, do you think that would be useful in this kind of jurisdiction, Alexander?
I think it's pretty vital. I don't think it would have helped Mr. Cambly, who I don't think has missed any tricks here. I think that one would have been horrific to manage. But as a firm, we have our approach. Think it's the right one. Think it's workable and fair. I think the PDF is also looking at whether we ask our members to voluntarily consider signing up to that sort of protocol, so that we know who we're dealing with. I think the key thing is, and the OG, of course, consult with them about it. They should be encouraging that kind of good practice. But I think consistency amongst professionals, but also consistency with how the court manages these types of applications is absolutely key. Knowing how they're going to be dealt with.
Yeah, I mean, I suppose the difficulty you have, like with any jurisdiction, with consistency of decision, is that because they aren't reported very often in COP cases, unless they are ones of significance like this one, then it leads to other courts and other practitioners not necessarily knowing what the outcomes are. And I think one of the challenges with this jurisdiction is that because it's actually relatively new compared to other aspects of law, there is sometimes less experience on the ground to then convert into judicial experience. But it relies on people like us talking about the cases in which we're involved, so that everyone understands where the range of kind of reasonable outcomes are. But then in the same vein, you've got things that are so fact specific. And so even though you may have this pre-action protocol, it may not, in a particular case, for example, in Cambly's case, lend that well to actually assisting the parties. So I think you're right. It was so far gone there that it was probably beyond repair. But just on that, I mean, irretrievable breakdown is the term that's kind of used a lot in these applications. In your experience, what do you class as an irretrievable breakdown?
My experience is when the family have completely shut up shop and they are the only access to P. So if the relationship breaks down with the firm as a whole, not just the deputy, but also any member of the team who the deputy might have tried to introduce to repair the relationship, and it's just not getting anywhere, there is a chance that P could suffer. And I think that was the point that Honourable Judge Hilda was making in the case, was the magnetic importance, as you put it. The factor of magnetic importance was P's best interest. If you cannot repair it, you've taken all the possible steps. That would be irretrievable to me. But a communication breakdown where there is a window of opportunity to attempt to repair it wouldn't be irretrievable to me. And I think that if you followed the steps where you pick up the phone to the deputy before you make your application, and you try to facilitate that meeting, and that even if informal mediation will tell you whether there is a prospect of repair.
And I think, that's where it's. I mean, I think with an irretrievable breakdown, you've got to first look at whether there is a breakdown, and that requires consideration of the factual circumstances. But then you say there's this window of opportunity. Can it be salvaged? Because an irretrievable breakdown suggests that everything possible has been done to repair it, but it can't be. And so that's why I think people making the application have this window of opportunity to take steps to repair it.
Yeah, I think you need to be very careful as an applicant to use that phrase. I also have a lot of sympathy with Mr. Cambly's point that, I mean, effectively it seems like his staff are being abused, and I think
it
myself and many people on this webinar would probably take the view that they can't tolerate that kind of behaviour. I wouldn't put their paralegals or solicitors in that kind of line of fire. So it does go both ways.
Yeah, definitely. And I think that if the other point I was going to say is that even if you have a poor relationship, that doesn't mean it's irretrievably broken down. And I think that's where it requires serious taking stock, because you may have a poor relationship where you just don't like the file handler because you've got on the wrong foot, and that personally can't be repaired because it's too far gone. But the deputy can still operate. The deputy can still make the decisions, and it's going through email contact, but they just won't speak over the phone. I have seen applications made on that kind of factual background, and to me, that isn't an irretrievable breakdown. And so that is where I think that if you are making those applications, that is where there are the cost risks to those parties, because one aspect that, as I say, judges don't like is for P to pay the costs of a dispute. And one thing that I find very frustrating, and I know that many of my other solicitors who are involved in these applications with me, is that actually in all property and affairs applications that become contested, you have this competing balance between the costs of the litigation and P's best interest. And I've had said to me on a number of occasions at a dispute resolution hearing, well, we just need to settle this because it's going to cost too much to go to a trial and P will have to pay for that. And then it becomes, well, the outcome of the litigation or settlement is dictated by the costs. And so the parties don't feel they can actually properly address the substance of the application and the merits or otherwise. So as the further you go into the application, the balance starts to tip in favour of the costs, and there becomes less consideration of the actual merits of it. And I know that's of real frustration to a lot of deputies who are on the other side of an application, because they feel that they can't compromise P's best interest. But by contesting an unmeritorious application, by virtue of that, they feel they're not acting in P's best interest because it's going to incur P costs. And that, I think, leads to two issues. The first is that, well, think about what your response to the COT1 application is going to be. As I say, I think a deputy in most circumstances is actually under an obligation to set out the relevant factual circumstances and to set out their view on best interests. And they can probably take a positive approach, but also push back on costs as well, because there is the power afforded to the court to depart from the general rule. And I say this in all my seminars, there is an increasing appetite from court of protection judges to adopt the civil cost rules, which is where if someone has behaved inappropriate in an application, they've brought an application that should never have brought, or they didn't consider settlement and all those things, they will be open to a submission that the losing party, or even not the losing party, will have to pay, or at the very least bear their own costs. And that is an outcome that I see quite routinely, actually. I mean, do you think that, Alexander, is a sort of sufficient safeguard to prevent sort of unmeritorious applications being brought?
I think the court probably, it would be more beneficial for the court to take a more managed approach to these types of applications. I mean, when you submit a statutory will application, there's a standard order giving out lots of directions that we have to follow. Why not direct the parties to respond on the steps taken to try to repair the relationships? So trying to get this out first, and if it can go through a mediation before it gets to the point of enormous litigation costs over something that's quite straightforward. Is a relationship shot or is it not? That would be preferable for me. And then even if you get to the point where the deputy does need to change, I mean, in the case where you're appointing lay deputies, the court could take steps to restrict the lay deputies' powers. They restrict any powers. You could say you can't draw down more than £50,000 a year from an investment portfolio. I mean, I've seen that in a professional deputyship order. The OPG could take an increased level of supervision for those types of files, because it may be that the layperson is the best person to take it on rather than a panel deputy. I mean, we have to think about the position of panel deputies and sympathise with them. I mean, I'm not one and don't want to be one, but the idea that they are chosen and parachuted into these families' lives without invitation from the family, and don't know who they are, and the first thing they need to do is essentially take over everything and get to grips with it. I mean, really difficult and taxing task to take on. But also back to the lay deputy point, the time limited order, so that the court can look at how well the lay deputyship is going. There are different steps that the court could take, in my view. They might have reasons why they couldn't, that would avoid those types of costs. But ultimately, if it is an unmeritorious claim, application, I would be very shocked if the court didn't exercise its discretion on costs.
There's just a question here. As the authorised officer of a local authority, I've received a number of requests from solicitor deputies for the local authority to agree to take over as property and affairs deputy for a client with diminishing funds on the premise that the local authority would now be the most appropriate deputy. Does the panel have a view on such requests? Ultimately, your initial appointment, has to have the consent of the local authority. So whilst the presently appointed deputies may apply some sort of pressure on the local authority to take on the case, it's within your gift to say no, and many of local authorities will do that. I act for local authorities all the time who refuse to take on any deputyships because it's very often easy for a judge to say, especially if there are issues of safeguarding, well, the local authority can do it. But even though they're a local authority, they still have to have the consent of the local authority. And if you, as a local authority, have a rule that you don't want to do it, or in that particular case you don't want to do it, then you're not obliged to say yes, and the court can't force you. Once you're appointed, that's when it becomes different, because then once you've accepted that appointment, it's at the discretion of the court, because the appointment of deputy is a procedural issue. And it's not actually, and I've had this discussion with a number of people, the actual choice of a deputy is not necessarily a best interest one. It's an issue of suitability. So it's actually a procedural point. But once the local authority were appointed, then it would have to convince the judge that it was in BNP's best interest to change for the reasons that we've identified. So you may want to take those appointments, but you certainly don't have to. One of the points that I just wanted to pick up on that you mentioned, I think this is an important one, is we've spoken a lot about the family members being challenging. P can also be challenging. And I find this more often with individuals who suffer from brain injuries, especially those who are perhaps more high functioning. And so they have perhaps more involvement with a deputy. And sometimes you will have P say, I don't like that deputy. I want to go back to my old one, or I want to go to a new one. And I suppose it's about how much weight you place to P's wishes. Because sometimes P may not want a deputy, and that's a manifestation of their impairment because they don't understand that they need someone to manage their affairs. And so if you are being approached to do that, you do need to, I think very carefully about whether the request is a manifestation of the impairment or whether it is genuinely because there is a breakdown in a working relationship between P and the deputy. And what, as a point of practice, I often find Judge Hilda is open to is where you have those difficult cases, she will often make an order that any new application is referred to her for consideration on the papers as kind of triage service. And I've certainly invited judges to do that in other applications, because sometimes deputies have said to me, well, can the court stop P from making an application? And I've had this submission made in front of Hilda before, and her sort of went in this exchange, we all sort of came to the view that there isn't the power of the court to do that. But the way you can cope with that is by having a sort of blanket order that there has to be a triage. So it filters out the unmeritorious applications. So that's the sort of way that I think can meet P's needs to maybe have the court relook at it if circumstances change, but also protect P from going to 10 deputies a month and seeing if they will change. And that's why you need that open conversation, don't you, between deputies, so that people understand what's going on, and that it's not just a race to make an application, I think.
Absolutely right. I mean, there might be very many reasons why P wants to think about changing, and it might be that they're not involved enough, or many other reasons. But ultimately, if P came to me and said, "I want to move to you because this deputy, I don't want to work for this deputy anymore," the first honest conversation I will have is that the starting point is that it may not be the best thing for you. What are the reasons? And to then liaise with the existing deputy to see if you can support P to understand.
Yeah.
But ultimately, I think if P's going to make an application, I don't think that the court could dismiss it outright, but I do well to involve and give P the chance to speak to the judge and explain in the best possible way.
And that's where you get the special visitors getting involved. Use the Section 49 power to ask the OPG visitors to go and speak to P to understand what their concerns are and have it. And this is why I always encourage people in this jurisdiction not to approach it with an adversarial mindset, because I truly believe that doesn't serve P's best interests. And, when I'm in a wills case, whatever view you have of the case, you're fighting your client's corner, and you're still doing that here, but there is another consideration, which is always P is at the centre of it. Just before we wrap up, Alexander, there's another question from Pokey. Just what are the position on lay deputies who have done no wrong and not by virtue of age or illness have been asked by P to be removed and replaced with someone else they prefer? What I preface this, Pokey, with, it depends, obviously, on the circumstances, but as a point of principle, if the lay deputy has done nothing wrong, there's no reason that makes them unsuitable. So you might, for example, have someone who is becoming so ill that they may have a dramatic decline, and so there may be an urgent situation that arises. At those kind of cases, there may be justification for it. But if they've done no wrong, it's just a case of P changing their mind. I wouldn't race to change that, to make an application to change that person. Obviously, it completely depends on the circumstances. But again, I say it's a procedural point. But having said that, on the flip side, there aren't the costs involved as much in changing a lay deputy, because you don't have that duplication of time. And so it's about doing your best interest analysis. If you have, if there's going to be very limited impact financially to P, and we can limit the costs of doing it, and P is actually going to be harmed by not having their application acceded to, that might tip the balance. But having said that, if they're a kind of repeat requester of a change of deputies, I think it's cruel actually to accede to P's request to change it, because the more you do it, the more they think that they can ask for it. And so it has to be handled very sensitively. And sometimes I think the responsibility is on us to sort of make it clear to clients that, actually, if you think about it holistically and not in a vacuum, it actually might be deleterious to P to encourage them to make more applications. So I can't give a definitive answer because also I don't know the circumstances. But the approach is still the same. You've still got to look at what can we do to try and repair the relationship? What steps can we take to not bring the application? And if after following those steps, the best interest analysis falls on the side of making the application, then that might so justify it. But so really, and it's so good to get your insight on things. I think it's really important for any practitioner, whether you're in litigation, whether you're in non-contentious, whether you're a judge, to get to understand what's going on the ground, because that's how we can all sort of work together to make sure P's best interests are always met. So everybody, thank you so much for attending. As always, I'll email it out to everybody. If you want to circulate it to your colleagues, by all means. And if you ever want to get in touch with me about anything, whether it be property affairs or just for a chat, then feel free. I am going to try and do another one before Christmas, just on bond applications, because I've had a couple of interesting cases arise out of that and some useful practical points, but it depends on workload. So just leaves me to thank you all very much. I hope you enjoyed it. Any feedback, let me know. And if you've got any questions, then do feel free to email me. Okay, thanks very much. Take care, everyone.